I have a first-time DUI. Am I going to be required to have ignition interlock? If you find yourself facing charges in Indiana for operating a vehicle while intoxicated, DUI, OVWI, again, all these terms are used interchangeably. One of the main questions our office gets all the time is, am I going to be required to get an ignition interlock device? Well, the answer is complicated because it depends. There are always going to be some circumstances in which it would be required and others which it might not be necessary. There's never a guarantee under any circumstance that you're never going to have it or that you will always have it, because when it comes to interlock and specialized driving privileges as a whole, it is 100% the judge's discretion. So it is always going to be up to the judge to determine whether or not ignition interlock is going to be required or necessary. With that being said, there is a circumstance in which ignition interlock will 100% always be required. And in some counties, that attaches to when you have a refusal. So if the police officer reads their implied consent card, I have probable cause to believe you're operating a vehicle while you were intoxicated. As such, I must offer you a certified chemical test. I must advise you, if you do not consent to a chemical test, your license will be suspended for 1 year. If you have a prior DUI or a prior refusal, your license will be suspended for 2 years. Will you now submit to a chemical test? If your answer to that question is anything but an unequivocal yes, the officer is going to mark it down as a refusal. Now, if you want to drive while your DUI case is pending and there's an alleged refusal, the only way that's possible is with ignition interlock. And even then, it's county specific. So not all judges are fans of letting people drive while a DUI case is pending. In fact, there are a lot of judges who don't believe in specialized driving privileges, or, especially when it comes to refusals, do not believe in allowing people to drive on that refusal while the case is pending. But if you happen to find yourself in a county in which DUIs and refusals or judges are more likely to grant driving while on a refusal, you must have ignition interlock. And that doesn't matter if it's your first time, second time, 100th time. The judge is going to grant interlock on a refusal every single time. It has to be interlock. That's what the law states. Now, let's go back to the certified chemical test. If you consent to it, say, yes, I'll blow. Yes, you can have my blood. As long as it's an unequivocal yes, you qualify for specialized driving privileges while the case is pending. Again, it is 100% the judge's discretion as to whether or not to grant those driving privileges. So let's say you are in a county in which the judge agrees to allow you to drive or agrees to have a hearing and grant specialized driving privileges while a case is pending. It is also up to that judge to determine whether or not ignition interlock is a requirement. Certainly, we will argue or make arguments to try to avoid the ignition interlock, but again, it's entirely up to the judge. Now, what are some of the things the judge looks at as to determine whether or not ignition interlock is appropriate for a first-time offender? Well, number one, what was the blood alcohol concentration? A lot of judges believe that once you start getting up to 0.15 and above, ignition interlock is almost a certainty in those situations because the judge has to maintain public safety. And ignition interlock is a great way for a judge to do that and kind of justify allowing people to drive while the DUI is actually pending. So one of the things the judge looks at is, what is their BAC level? Another thing a judge is going to look at, what's the criminal history? Does this person in front of me have a consistent criminal history involving drugs, alcohol, and things of that nature? Do they have a prior DUI way in the past? If the answer to those questions, or any of those questions, is yes, the judge is going to be more likely in this case to order ignition interlock. Another thing judges are going to look at is, what are the facts and circumstances surrounding the DUI itself? Is there an accident? Were you just going too slow? Certain facts, especially when it comes to accidents or speeding at a crazy high rate, judges are more likely to order ignition interlock. And then again, most people asking for specialized driving privileges while a case is pending revolves around a DUI. There's very few other crimes that result in a license suspension pre-conviction. DUI is the main one. So a lot of times judges say, well, you're charged with an alcohol offense. If you want to drive, I want to make sure the public is safe, you're going to have to blow into this. So is ignition interlock required? Not necessarily. But a lot of times a judge is going to order it for public safety reasons, for policy reasons, whatever it may be. And then if there's a refusal, then it's 100% required. Indiana law requires if a judge is going to grant driving privileges on a refusal, must be with ignition interlock. Doesn't matter if it's your first offense or your 10th offense. So if you find yourself charged with a DUI, find yourself struggling with, am I going to need ignition interlock? Am I not? Do I need a hardship license? Give us a call, 317-632-3642. Remember, always plead the fifth.